and a very warm welcome to yet another interesting edition of the program CAC Weekly, a weekly program that keeps you abreast on the activities and achievements of the Corporate Affairs Commission. I am Amina Jabril. In continuation of our efforts to dissect the CAMA 2020, its implementation and impact on businesses, we shall today take a look at its set objectives and some key innovations in the landmark law. But we will be right back after this break. Do stay with us. The CAMA 2020, the game changer as it is often called, is poised to further enhance and facilitate trade and investment in the country. The CAMA 2020 has 870 sections which are classified into chapters under Parts A to G. While Part A deals with the composition and administration of the registry which functions as a regulator. Part B has 29 chapters which stipulates the life cycle of companies from their incorporation through to liquidation. Part C and D have 11 and 2 chapters respectively and set out provisions that govern limited liability partnerships, LLPs, and limited partnerships, LPs. Parts E and F reprised sections on the registration and regulations of business name and incorporated trustees, with a few changes outlined in chapters 3 and 7 respectively. Part G introduces the quasi-judicial body. Quasi-judicial body, for the benefit of some of our viewers, according to Wikipedia, it defines it as an entity such as an arbitrator or tribunal board, generally of a public administrative agency, which has powers and procedures resembling those of a court of law or a judge, and which is obliged to objectively determine facts and draw conclusions from them so as to provide the basis of an official action. An important milestone for the business sector, the CAMA 2020 removes substantially a significant number of bottlenecks that hitherto prevents market penetration by micro, small and medium enterprises, MSMEs, and significantly reduces the reporting obligations and requirements that may ordinarily inhibit the growth of the MSMEs. CAMA 2020 is not just transforming the business environment, but also simplifying the process of company registration. In a chat with CAC Weekly, Mr. Justin Medea, Director Commission Secretariat, sheds more light on some of these changes, which include issued share capital, which replaces authorized share capital, separation of the office of the Chief Executive Officer, CEO, and that of the Chairman for Public Liability Companies, PLCs, as well as the threshold of a small company, among others.
Let's understand the objectives of CAMA 2020.
First of all, we will notice that before the repeal and reenactment of CAMA 2020, the previous law was operated for about 30 years. It was obvious that most of its provisions became obsolete. So there was a need to actually review it to bring it in tune with the current realities, particularly the demand of the global community. That is one. Two, there were also the need to make things easier for the business community. So these two broad objectives were what drove the repeal and the enactment of CAMA 2020.
Okay. Tell us some of the changes that the CAMA 2020 provided, especially in limited liability companies.
Well, there were several changes, broadly over 200 of them. Which we may not be able to talk about them in this short
Maybe you
period.
just pick the most significant ones.
Yes. So let me first of all say that the first one that we will notice is one, in an attempt to make the business environment much more easier, particularly for sole proprietorship. It introduced the concept of what we call one-man company. So before now, you required a minimum of 2 persons to register a limited liability company. But on accent to the CAMA 2020, it now became possible for one person to register a private company. So that was one great innovation that was introduced from the perspective of a limited liability company.
Okay.
Then another one that we also saw was the reform that was introduced into the requirement for the registration of company limited by guarantee.
Okay.
Before now, you required the consent of the Attorney General to register a limited liability company. There were challenges with that requirement because it took quite a lot of time sometimes before that access is given by the Honorable Attorney General. When that one is done, the Commission can now, based on the publication, register a limited liability company. So it's like it gave promoters of such companies an option if the Attorney General does not act within the 30 days specified by law. The third one is that we also note that the Act replaced the concept of what we call authorized share capital with issued share capital.
Okay.
And apart from that, it also reviewed upward the hitherto what we call a minimum threshold for capital requirements.
Okay.
Before now, the prescribed minimum share capital for private companies was 10,000 naira. For public limited liability company, it was 500,000 naira. But going forward, apart from replacing nominal share capital with issued share capital, private companies would be required to have a minimum share capital, of 100,000 naira.
Okay.
And
so with 100,000 naira, you're good to go.
Yeah, for private companies.
For private companies, okay.
But for public, it's a minimum of 2 million naira.
Okay.
So that is the one that was introduced with respect to issue of share capital.
Okay.
Then we also note that before the Act, there was a compulsory requirement for company seal for all limited liability companies. But going forward now, the issue of seal has been made optional for all classes of companies.
All classes, including the PLCs?
Including the PLCs.
Okay.
Yes.
Okay.
Then apart from that, we also noted that the Act tried to simplify things for company. So it made the requirement for company secretaries optional for small companies. Before now, every company, whether private, whether public, whether big or small, were required to have a company secretary. But going forward, only companies other than small companies will be required to have a company secretary.
Help us understand persons with significant control, when it comes to companies generally.
Okay. Well, persons with significant control refers to actual persons that have what we call controlling interest in a registered entity. And the threshold from our own perspective is a minimum of 5%. So once you have 5% interest, that's looking at it from ownership perspective now. Once you have 5% interest in a company, you will be considered as a person with significant control. And the law puts an obligation.
Just 5%?
5%.
What if somebody else has 95%?
Well, the minimum is 5%.
Okay, so once I have 5%.
Once you have more than that, you are also a person with significant control. That's not the only criteria, but that's the criteria from ownership perspective.
Okay.
So once you have 5%, the law places an obligation on you to give to within 7 days give the company a notice that you are a person with significant control.
Okay.
And the company also, when they receive the notice, they are expected to maintain a register of persons with significant control, and in turn give the commission within 30 days notice that they have received notice from this person that he is a person with significant control.
Okay.
And the commission is also required to keep a register of persons with significant control.
What about the issue of interlocking directorship for PLC, which is now limited to just 5%?
Well, before now, there was no restriction on on the number of legal entities.
Okay, but before you answer, let me jump in here.
Yes.
What do you mean by interlocking directorship?
We mean a person that is a director in more than one companies.
Okay.
Yes.
Okay.
So for public companies, the law puts a minimum of 5 companies. So if after the commencement of the act, you are a director in more than 5 public limited liability companies, then over a period you are required to disengage from the other ones and maintain only 5. The idea is that a director owes a lot of responsibilities individually to any corporate entity that he is a director in. So it is expected that for him to discharge those responsibilities properly, he should have sufficient time. Okay. Give sufficient time, give sufficient attention to any company to which he is a director. The thinking is that if it is more than 5, he may not have adequate time to give adequate time and attention to those companies. Yes.
Under the CAMA 2020, help us define what a small company is. You know, that's what appeals to most people, isn't it?
Yes. The law gives a specification that there should be what we call turnover. That once a company has a turnover of more than 120 million and a net asset of 60 million naira, it will be considered as a small company.
If it has more than?
If
or
it
below?
If it has.
Okay.
If it has below.
Okay.
Below those.
Below 60 million naira asset? And
below 60 million net assets
right.
and 120 million turnover.
Okay.
But what is often overlooked in that area is that the law also gives the commission to review this requirement. So it could prescribe a requirement that is above or below the threshold that is given in the act. So it's not that it's cast in stone.
Oh, okay.
So the understanding is that it just gives that as a guide.
Under the new law, we also understand that there is a separation of office of the chairman from the CEO. You know, we are used to CEO stroke chairman or chairman stroke CEO.
Yes, before now, you could double as a chief executive officer and a chairman of a company. But going forward, because of the requirement of checks and balances, it was thought that it is wise that those offices should be separated so that the chairman could act as a check on the activities
of the CEO.
Of the CEO.
What if it's a one-man company? I'm the only owner of the companies. I can double as a CEO and chairman, can't I? If it's a one-man company.
Yes, for one-man company, there might not be an issue with that.
There might not be, or there's no issue. Under this new law.
Under this new law, the requirement of separation
doesn't apply.
It doesn't apply
to a one-man company.
To a one-man company.
Okay.
Yes.
But for a PLC, it does apply.
But for a PLC, yes.
Okay. So for PLC companies, there's not going to be chairman stroke CEO.
No.
There's going to be the office of the chairman and office of the CEO.
The CEO.
And you said the office of the chairman is supposed to checkmate the activities of the CEO.
That's what it should be.
Help us understand, what does all of this mean for the business environment?
When we look at the Act broadly, it tries to simplify things for those that are into day-to-day management of companies. So the Act seeks to simplify compliance procedure for all class of entities. Then apart from that, it also tries to improve corporate governance for the companies generally. So there are additional disclosure requirements, part of which we have already mentioned. Then there is also an attempt to actually bring the level of company law and practice in the country to par with what obtains in the global community. So that basically is what CAMA seeks to attain. And we can say without fear of contradiction that it has largely achieved those objectives.
How flexible is CAMA 2020?
It's flexible in the sense that
especially in the area of sanctions.
It gave the Commission the power not only to prescribe fees, but penalties as well. And it sought to do that in a different way, because under the old regime, penalties were codified or were put in the body of the Act. So what that meant is that you cannot alter the penalties and the fines without amending the law. But what this one did was that it gave the Commission and the Minister the power to not only fix fees for services, but to also prescribe penalties and fines that will even be administered by the court. So by that, it made it flexible that once there is a need to amend the fees, the penalties, and the fines, the Commission, along with the Minister, can easily do that without substantive amendment to the law itself.
People should not have any concern or worry as far as the sanctions are concerned.
There is no need to worry about the sanctions, because the law has simplified compliance procedure.
Okay.
And the only person that may be afraid is the person that deliberately violates the provisions of the law, because it has simplified things. So the expectation is that people will now have it easy, and there will be less reason not to comply with the requirements of the Act. But also, we need to say that the penalties need to be balanced to discourage.
So the penalties are not balanced now?
The penalties before, because what we said before was that they were contained in the Act. Some of them, after 30 years, you are talking about 5 naira, 100 naira. So, but now it has been reviewed to take care of current realities. But it's not going to be as stiff as people think. So, but where there is a need to discourage a behavior, then the penalties have to be stiff also to discourage people from violating those particular sections.
As we wind down, for a lot of Nigerians, having the law is one, implementing it to the fullest is another issue. And we have issues in this country when it comes to implementation. So what kind of implementation are we going to see with the CAMA 2020?
Before the act was passed, the commission was already in the picture. It prepared itself to hit the ground running once consent was given by Mr. President. So there was a draft regulation that was prepared. The draft regulation was exposed to members of the public for comments, and the comments was received. And the commission has reviewed the initial draft in line with the suggestions that were made from the general public. The regulation now has been sent to the minister for approval. As soon as that one is done, the commission will hit the ground running. And that is not all. What we have noted is that the new CAMA also requires a complementary ICT facilities that will drive it. So the Commission has been working assiduously to ensure that the ICT requirements are put in place so that we roll both of them, both the regulations and the ICT facilities, we roll them out at the same time. So that the general public for which the law is meant will have a seamless interaction with the Commission.
All right.
Yeah.
Mr. Justin Nadia, Director, Board Secretary at Corporate Affairs Commission, thank you very much indeed for your time.
Thank you. It's a pleasure to be here.
The Common Allied Matters Act 2020 is one of the very aggressive attempts by government to properly bring the business sector into focus. Having realized that incorporation and management of company is the first step towards investment in any country, that simplify the process and make it very easy for small businesses. Take for example now, if your turnover is less than 25 million, you don't have to do audit. And so if your company has not started business, you don't also need to file an audit before the corporate affairs. These were major bottlenecks that affected access to business for small businesses. So it's a welcome development. And the way it has also been made, there's also room for limited partnerships. Now, where if you have a partnership, you can have it just like a limited liability company. Unless you want to raise funds, then you need to now register as a limited liability. And you also have situations, one of the biggest problems for us, at the end that you want to form a company, you need to have a partner. But now you are allowed to form, if it's a private company, as an individual. So this confidentiality that normally comes with ownership and this thing now has been minimized now. So there's a legal process where you can form company as an individual. So there are several other things that were incorporated, which have made it a lot easier. At NACIMA, we fully embrace it, we are part of it, and we are ready to partner.
And this is where we draw the curtain on this week's edition of the program, CAC Weekly. We do hope you enjoyed watching. For comments and inquiries, please take advantage of our social media handles and our helplines. On Twitter, it is at CAC Nigeria 1. On Instagram and Facebook, it is Corporate Affairs Commission. Our email is cservice@cac.gov.ng. Our website is www.cac.gov.ng. And our helplines are 081-822-99016 or 081-822-98971 or 090-874-01598 or 090-874-01599 and 090-874-01600. Do join us next week for another interesting edition of the program. Same time, same station. From me, Amina Jibril, and the whole team here, it is bye for now.